that Jowie Irungu was in the same class with Monica Kimani. That's the number one thing that Jowie Irungu did. Akadanganya. Yet the parent was saying that yes, it's true that Jowie Irungu alikuwa shule moja na Monica Kimani. Right now that you know very well that Jowie Irungu has been declared guilty and life imprisonment by Grace Nzioka today, right now in court. Today, we don't know if Jowie Irungu is going to appeal. We don't know what is going to happen, but he's going to committee prison after being declared guilty, going to serve his life sentence in prison. Number two reason why Jowie Irungu alikuwa declared guilty is the blood stain. The blood stains of Monica Kimani were found kwa nguo zenye Jowie Irungu alikuwa amevaa. Hapo ndo venye ziliweza kupatikana, the blood stain. Dear viewers, that is number two thing, that reason why the court wanasema that Jowie Irungu was declared guilty. Hapo ndo penye alipatikana. Blood stain ulitoa wapi? Unaona? Hapo ndo penye inafanya sisi Kenyans to shuku that Jowie Irungu was the suspect, the main suspect in the murder of Monica Kimani. Blood stains of the deceased ulitoa wapi? That is the question that so many people, hata ukijaribu to convince people that you are innocent, it's very hard for you to be able to convince people because of the blood stains that were found kwa nguo yenye ulikuwa umevaa. Number three reason why Jowie Irungu ako guilty is they don't ignore the man with a vision, because there is a time that you will see the man that you ignore that had a vision in your own television. That is my advice for you, for me, to you today. Determination is success. Whenever you want to start something, just ask for information. Uliza hapa na pale. Because the time that you ask someone for information while you start, you are going to flourish. But because the time that you don't ask, you are going to drop and forget about it, what you are doing. Hello guys, welcome to the Dorian 254. Hapa ni the Dorian 254. We bring you trending story. Today I'm alone. As you can see that today I'm alone. I promise that tomorrow we are going to be with Monica Kimani. Today we want to talk about the story of Jowie Irungu. This is what is happening today. Today on the 8th of March, you know very well that Jowie Irungu was the main suspect, was allegedly the main suspect of the main suspect in the killing of Monica Kimani. Mnajua vizuri that Jowie Irungu alipatikana. Jowie Irungu came to the limelight in the year 2018 June 8th. That's the time that Jowie Irungu proposed to Jackie Maribe. Hapo ndo penye watu walianza kujua who is Jowie Irungu, where does Jowie Irungu come from, because he was the boyfriend of Jackie Maribe na alimpropose to her on public. Hapo ndo penye watu waliweza kujua Jowie Irungu. Okay, in the same year September, that is when people pia wakakuja kujua Jowie Irungu ni nani. After the murder of Monica Kimani at Lumuria Gardens in Kilimani. Hapo ndo penye watu wakaanza kujua who is Jowie Irungu, Jowie Irungu anatoka wapi, Jowie Irungu ana nini hapi. You know that on February last month, Judge Grace Nzioka determined that Jowie Irungu was guilty of murder. Alipatikana kama ako guilty of murder. We don't know if it's true, if it's wrong. Okay, this is the reason why Jowie Irungu was declared the main suspect in the murder of Monica Kimani, and the reason why Jackie Maribe was declared innocent. First of all, number one reason why Jowie Irungu was the main suspect in the murder is the lie. Jowie Irungu lied. Alidanganya kwa court that he didn't know who is Monica Kimani. Yet, they were in the same school. That is TUM, Technical University of Kenya. Kitambo ilikuwa inajulikana kama Kenya Poly. They were in the same school with Monica Kimani in the year 2012. Hiyo ndo time penye walikuwa pamoja. Walifanya investigation, the DCI did the investigation, they found it was true that Jowie Irungu was in the same class with Monica Kimani. That's the number one thing that Jowie Irungu did. Akadanganya. Yet the parent was saying that yes, it's true that Jowie Irungu alikuwa shule moja, that Jowie Irungu was in the same class with Monica Kimani. That's the number one thing that Jowie Irungu did. Akadanganya. Yet the parent was saying that yes, it's true that Jowie Irungu alikuwa shule moja na Monica Kimani. Right now that you know very well that Jowie Irungu has been declared guilty and life imprisonment by Grace Nzioka today, right now in court. Today, we don't know if Jowie Irungu is going to appeal. We don't know what is going to happen, but he's going to committee prison after being declared guilty, going to serve his life sentence in prison. Number 2 reason why Jowie Irungu alikuwa declared guilty is the blood stain. The blood stains of Monica Kimani were found kwa nguo zenye Jowie Irungu alikuwa amevaa. Hapo ndo venye ziliweza kupatikana, the blood stain. Dear viewers, that is number 2 thing, that reason why the court wanasema that Jowie Irungu was declared guilty. Hapo ndo penye alipatikana. Blood stain ulitoa wapi? Unaona, hapo ndo penye inafanya sisi Kenyans tushuku that Jowie Irungu was the main suspect in the murder of Monica Kimani. Blood stains of the deceased ulitoa wapi? That is the question that so many people, hata ukijaribu to convince people that you are innocent, it's very hard for you to be able to convince people because of the blood stains that were found kwa nguo yenye ulikuwa umevaa. Number 3 reason why Jowie Irungu ako guilty is the doctrine of last sin. Dear viewer, be very careful with this statement. Doctrine of the last sin is you are the last person to be seen by the deceased. Wewe ulikuwa mtu wa mwisho kuonekana na Monica Kimani. So itakuwa ngumu sana ku convince watu that I didn't kill him, nani alimuua, I was not the main suspect, I didn't do that. That is the reason why ulikuwa declared guilty in the murder. You are the main suspect in the murder of Monica Kimani because of the doctrine of the last sin. Ulikuwa mtu wa mwisho kuonekana na yeye. You know, in the party ulikuwa na yeye pamoja, mka happy, mkakuwa pamoja. Hapo to that time when Jowie Irungu alicall the brother that he has arrived in Nairobi. You know very well that Jowie Irungu alikuwa anafanya job in Juba, that is Sudan, South Sudan in Juba. Hapo ndo penye alikuwa anafanya kazi. That is the number 3 reason why Jowie Irungu is declared guilty in the murder of Monica Kimani, a business lady from Juba, but he lives in Kenya. All the parents are living in Kenya. That is the reason why Grace Nzioka determined that Jowie Irungu, hautadanganya watu that you are not the main suspect in the murder of Monica Kimani. You don't know what is going to happen. Will Jowie Irungu going to appeal? Jowie Irungu anaenda kufanya nini? We don't know. We don't know what is going to happen. Dear viewers, keep on the Dorian production for trending story. What is going to happen? Nini inaenda kufanyika? We don't know if the DPP, you know very well that DPP pressed charges against Jackie Maribe. And Jackie Maribe, followed by the friend Dennis Itumbi, pia walisema that they are going to press charges against the DPP, the former DPP. Hii inaenda kuwa normal. We don't know what is going to happen. It's going to be, keep it the Dorian production. If you haven't subscribed, please subscribe, like, comment, and you will be able to keep updated of what is going to happen in the land of entertainment. Let's meet in our next episode. That Jowie Irungu was in the same class with Monica Kimani. That's the number 1 thing that Jowie Irungu did. Akadanganya. Yet the parent was saying that yes, it's true that Jowie Irungu alikuwa shule moja na Monica Kimani. Right now that you know very well that Jowie Irungu has been declared guilty and life imprisonment by Grace Nzioka today, right now in court. Today, we don't know if Jowie Irungu is going to appeal. We don't know what is going to happen, but he's going to committee prison after being declared guilty, going to serve his life sentence in prison. Number 2 reason why Jowie Irungu alikuwa declared guilty is the blood stain. The blood stains of Monica Kimani were found kwa nguo zenye Jowie Irungu alikuwa amevaa. Hapo ndo venye ziliweza kupatikana, the blood stain. Dear viewers, that is number 2 thing, that reason why the court wanasema that Jowie Irungu was declared guilty. Hapo ndo penye alipatikana. Blood stain ulitoa wapi? Unaona, hapo ndo penye inafanya sisi Kenyans tushuku that Jowie Irungu was the main suspect in the murder of Monica Kimani. Blood stains of the deceased ulitoa wapi? That is the question that so many people, hata ukijaribu to convince people that you are innocent, it's very hard for you to be able to convince people because of the blood stains that were found kwa nguo yenye ulikuwa umevaa. Number 3 reason why Jowie Irungu ako guilty is they don't ignore the man with a vision. because there is a time that you will see the man that you ignore that had a vision in your own television. That is my advice for you, for me, to you today. Determination is success. Whenever you want to start something, just ask for information. Uliza hapa na pale. Because the time that you ask someone for information, while you start, you are going to flourish. But because the time that you don't ask, you are going to drop and forget about it, what you are doing. Hello guys, welcome to the Dorian 254. Hapa ni the Dorian 254. We bring you trending story. Today I'm alone. As you can see that today I'm alone. I promise that tomorrow we are going to be with Monica Kimani. Today we want to talk about the story of Jowie Irungu. This is what is happening today. Today on the 8th of March, you know very well that Jowie Irungu was the main suspect, was allegedly the main suspect of the main suspect in the killing of Monica Kimani. Mnajua vizuri that Jowie Irungu alipatikana. Jowie Irungu came to the limelight in the year 2018 June 8th. That's the time that Jowie Irungu proposed to Jackie Maribe. Hapo ndo penye watu walianza kujua who is Jowie Irungu, where does Jowie Irungu come from, because he was the boyfriend of Jackie Maribe na alimpropose to her on public. Hapo ndo penye watu waliweza kujua Jowie Irungu. Okay, in the same year September, that is when people pia wakakuja kujua Jowie Irungu ni nani. After the murder of Monica Kimani at Lumuria Gardens in Kilimani. Hapo ndo penye watu wakaanza kujua who is Jowie Irungu, Jowie Irungu anatoka wapi, Jowie Irungu ana nini hapi. You know that on February last month, Judge Grace Nzioka determined that Jowie Irungu was guilty of murder. Alipatikana kama ako guilty of murder. We don't know if it's true, if it's wrong. Okay, this is the reason why Jowie Irungu was declared the main suspect in the murder of Monica Kimani, and the reason why Jackie Maribe was declared innocent. First of all, number one reason why Jowie Irungu was the main suspect in the murder is the lie. Jowie Irungu lied. Alidanganya kwa court that he didn't know who is Monica Kimani. Yet, they were in the same school. That is TUM, Technical University of Kenya. Kitambo ilikuwa inajulikana kama Kenya Poly. They were in the same school with Monica Kimani in the year 2012. Hiyo ndo time penye walikuwa pamoja. Walifanya investigation, the DCI did the investigation, they found it was true that Jowie Irungu was in the same class with Monica Kimani. That's the number one thing that Jowie Irungu did. Akadanganya. Yet the parent was saying that yes, it's true that Jowie Irungu walikuwa shule moja, that Jowie Irungu was in the same class with Monica Kimani. That's the number one thing that Jowie Irungu did. Akadanganya. Yet the parent was saying that yes, it's true that Jowie Irungu walikuwa shule moja na Monica Kimani. Right now that you know very well that Jowie Irungu has been declared guilty and life imprisonment by Grace Nzioka today, right now in court. Today, we don't know if Jowie Irungu is going to appeal. We don't know what is going to happen, but he's going to committee prison after being declared guilty, going to serve his life sentence in prison. Number two reason why Jowie Irungu alikuwa declared guilty is the blood stain. The blood stains of Monica Kimani were found kwa nguo zenye Jowie Irungu alikuwa amevaa. Hapo ndo venye ziliweza kupatikana. The blood stain. Dear viewers, that is number two thing, that reason why the court wanasema that Jowie Irungu was declared guilty. Hapo ndo penye alipatikana. Blood stain ulitoa wapi? Unaona? Hapo ndo penye inafanya sisi Kenyans tushuku that Jowie Irungu was the suspect, the main suspect in the murder of Monica Kimani. Blood stains of the deceased ulitoa wapi? That is the question that so many people, hata ukijaribu to convince people that you are innocent, it's very hard for you to be able to convince people because of the blood stains that were found. Number three reason why Jowie Irungu wako guilty is the doctrine of last sin. Dear viewer, appear for the victim's family. is you are the last person to be seen by the deceased. Wewe ulikuwa mtu wa mwisho kuonekana na Monica Kimani. So itakuwa ngumu sana ku convince watu that I didn't kill him, nani alimuua, I was not the main suspect, I didn't do that. That is the reason why ulikuwa declared
judgment on sentence in the subject matter, High Court Criminal Case number 51 of 2018. This court delivered its judgment in this matter in the presence of the parties and the accused person on the 9th day of February 2024. And the last time we were before this court, last week on Friday, the court did not deliver its judgment on sentence because the parties had not filed all the documents. I am happy to report that eventually the accused and/or the defense filed their mitigation submissions by end of day on Monday. And so the same has been considered in the decision that I'm going to deliver just now. Sorry. So, I believe that we are able to follow the judgment in English language. In case there will be need for me to translate any of the judgment, I'm just too happy to do that. Again, I'm going to deliver this judgment in as simple, clear language, hopefully, that we can be able to follow. So as I've already said, this judgment is being delivered pursuant to the judgment that the court delivered on 9th of February 2024. In this matter, which was initially a charge against two accused persons, the accused person before the court was the first person. Do you want to stand or you want to sit? I don't mind you sitting. You can sit. You want to stand? If you're okay with that. So the accused person before the first accused person found guilty by the judgment delivered on 9th of February 2024. The second accused person was found not guilty of the charge that was prepared against her, which was a charge of murder, contrary to section 203, as read together with section 204. She was accordingly acquitted, and therefore she does not and is not a subject. In the judgment before this court, which I am not going to read in details, but I'm sure the counsels will have the benefit of this judgment before end of day, I have discussed what sentencing is all about in about 3 paragraphs. And my conclusion thereof is that it is the final decision of the court on the sanction which an accused person has to suffer for his acts and or omission that constitutes an offense. That you'll find discussed in one of the journals in the New Zealand, which I've quoted, the Canadian, not New Zealand, Canada, the Canadian Sentencing Commission of 1987, which simply says that is a legal sanction to be imposed on a person found guilty of an offense. A writer by the name of Rabindra Bharatani says that sentencing is a judgment of the court of law under legitimate jurisdiction, where formal declaration of legal consequences of acts or omissions of an accused person is pronounced. It is a stage at which an accused person who has been convicted bears the legal consequences of his action. I want to draw us much more closer home in relation to the same, and you may want to look at clause 1.1.1 or our sentencing guidelines of 2023 that says that sentencing is a process by which a court imposes penal sanctions once an accused person has pleaded guilty and has been convicted. I thought it is important to put the exercise of the court's sitting today in perspective by understanding that it's the last stage of the criminal trial. The other issue I want to speak to is the importance of this particular process. Most of the time, it is an understanding that our criminal justice system starts with reading out of the charge, taking a plea on the same, trial where there's a plea of not guilty, findings of the court as to whether an accused person is guilty or not guilty, and then that's it. And very little importance is attached to the process of sentencing. And we may want to understand that is a central task in the administration of justice. And in that regard, may I refer you to clause 4.61 of the guidelines that I've just spoken to, that says that it is a central and an important process. And we'll be finding out why it's important and why it's central to the criminal justice system. In addition to the clause I've given you, may I also refer you to the case of the Attorney General versus Susan Kiguta. Is a constitutional appeal, number 3 of 2006. And just to put the point I am buttressing in perspective, let me just read 2 lines of what the court said in that matter. It said that a trial does not stop at convicting a person. The process of sentencing a person is part of the trial. This is because, and I want to lay emphasis on what I'm just about to read, because I think that is what this court was required to do, and we will be interrogating as to whether that was done. That it is a process of sentencing and is part of the trial because, 1, the court will take into account the evidence. So there is also an understanding that at the stage of sentencing, the court shuts itself to the evidence that was adduced. That is not the correct position. And so one of the factors that this court has to take into consideration is the evidence that was adduced at the trial and the basis for conviction. The other aspect and factor that the court will take into account that makes this stage to be a critical stage of the trial is the nature of the offense. So the court will have to go back and look at what is the offense that the accused person is charged with. And again, in addition, the court will have to take into account the circumstance of the case. And each case is treated on its own unique circumstances. Why are these factors important? Because at the end of the day, the question that the court must ask and answer is whether the sentence that this court will mete out in this matter today is the appropriate sentence. And more so, whether it meets the interest of justice. Please have a further reading. The case of Anton Paraido versus the State of Mahindra is an Indian case and speaks again to the importance of the process we are in today. And it says that sentencing is an important task in the matter of crime. And again, the reasoning for that is that at the end of the day, the court has to decide an appropriate, adequate, just, proportionate sentence that is commensurate to the offense an accused person is being charged with and convicted of. Having then looked at what sentence is and the importance thereof, let me get now back home. The case of Muratetu. We are all very familiar with the case of Muratetu. The case of Muratetu appreciates under paragraph 41 of the judgment of the Supreme Court that this is an important stage of trial. And they just use the same words and say at paragraph 41, it is evident that the trial process does not stop at convicting the accused. And the court said this: there's no doubt in our minds that sentencing is a crucial component of a trial. It therefore follows that once the court has arrived at a verdict of guilty, convicted, then the door to sentencing opens. And there are two questions that the court then will have to deal with. And the first question is, what would be the reasonable corresponding punishment for the offense? What would be the reasonable corresponding punishment for the offense? And two, whether that sentence, after it's been pronounced, was fair, appropriate enough to serve the interest of justice. In the course of the trial on sentence, general principles that guide sentencing have evolved, and I'll speak to them very briefly and make them as simple as I can. And I am laying this background because it will have a bearing on the final decision of this court in this matter, so that you have a deeper understanding where the court was operating from to arrive at the sentence that will eventually be pronounced in this matter. So the recognized principles of sentencing includes one, minimum intervention. What does it mean? It means that an accused person, a convicted person, must benefit from the less severe minimum sentence. The second principle, and for the lawyers you'll find this expounded in depth. I'm simply picking up the summary thereof. So before I go to the second principle, may I draw our attention to the fact that this principle of minimum intervention is amplified and recognized in our Constitution, and I draw your attention to Article 50 of the Constitution of Kenya that says that an accused person should be given the benefit of the least severe sentence, and especially if there has been change in law in relation to that sentence between the time that accused person was charged and at the time the court is pronouncing its sentence. The second principle that we speak to is the principle of equality before the law. And what that principle speaks to is also reflected in our Constitution. And I want to draw your attention to Article 27, that in pronouncing a sentence, in meting out a sentence against an accused person, it should not be based on any of the factors stipulated under that section, which includes race, sex, color, religion, that would prejudice that accused person. I speak to these things to bring to your knowledge that these are matters the court is live to and matters the court has considered in meting out the sentence herein. The third principle is on proportionality. And this principle on proportionality speaks to two areas. That in deciding what is the appropriate proportional sentence to give, the court will take into account the aggravating and the mitigating factors. And so I am quite live to the fact that it will be important for the court to consider what are the aggravating factors and what are the mitigating factors. I'll be speaking to these principles later as I apply them to the matter before this court. The next principle speaks to imprisonment as the last resort. And this principle has evolved because, according to what is said to be research, it does appear that imprisonment does not even deter commission of an offense. That is the argument for those who have advanced this principle, and that the imprisonment should be the last resort. The other principle speaks to cost effectiveness, that before the court pronounces a sentence, it should stop and ask, what is the cost of, for example, if I may come back home, sentencing a person to prison, what is the economic impact to the society? And in fact, the argument behind this is that if the court finds the prisons are congested, then we might as well defer the sentence and wait for the congestion. I'm speaking to the principles that are generally, globally applicable in terms of sentencing. Let's come back home. What are the guidelines speaking to? So the sentencing guidelines at clause 1.2 guides the court to take into account the following areas in determining sentence, and the first factor is proportionality. And it states that the sentence meted out should and must be proportionate to the offending behavior, meaning that it must not be more or less in view of the gravity of the offense. The other principle or guideline under the sentencing guideline is equality, uniformity, parity, consistency, and impartiality. And I am sure even if one just picked one, that is consistency, that there should be consistency in the sentences that are meted out in relation to same or similar offenses. The sentence should speak to the principles and guidelines of accountability and transparency. The court should be able to give reasons why it has meted out the sentence that it has meted out. The other principle and guideline is inclusiveness, and this is very important. It requires the court to hear both the offender and the victim before pronounces its sentence. There is need to respect human rights and fundamental freedoms of the parties that are involved, and in this case, of course, the accused person. And finally, the sentencing guidelines requires this court to take cognizance of the need to enhance compliance with the domestic laws and international instruments, and we are all aware that Article 2, Sub-Article 5 and 6 of our Constitution requires that the court takes into account all the treaties and conventions that have been ratified that form part and parcel of the law of this country. So those are factors this court needs to address in deciding the sentence in this matter. So, but what then are the objectives of punishment? And again, I seek of your attention because this is very important. The generally accepted goals and objectives of punishment includes but are not limited to retribution. And that entails the punishing of the offender for the conduct, and that punishment be meted out in a just manner. The second objective of sentencing is deterrence. And I'm looking at deterrence in two categories, and that is basically the position. There is individual deterrence and there is general deterrence. And individual deterrence is where the offender is being deterred from committing a similar offense in the future, and the general deterrence targets the public that any other person who intends to commit a similar offense should be deterred. Again, very critical. I'll be speaking to the same as I revert back to this matter. The third objective and goal of sentencing is rehabilitation. I think the word speaks for itself, whereby the sentence aims at giving the offender, the convict, an opportunity to be rehabilitated through designated, designed programs with a view that the offender can reform and be reintegrated back into the society. I'll combine the other two objectives together, and that is restorative and restitution. Those two objectives speak to the offender remedying the wrong in form of compensation, and I would take an order where the court, for example, orders that you have caused harm, and so you need to instead restitute, to bring back the victim to the position that victim was before the offense was committed. I am speaking to all these objectives because we shall be interrogating them and finding out which one is suitable in this given matter. The other goal that we need to address is community protection. And the question the court must ask is this: does the sentence that has been meted out protect the community from the offender? Denunciation. Does the sentence clearly communicate the community's condemnation of the offense? Reconciliation. Should the court order reconciliation, where the family of the victim and the family of the offender sit together and reconcile? And finally, reintegration. Is the sentence of reintegration appropriate, whereby you allow the accused person to go back and be reintegrated? And so, how does the court in the process of this trial deal with the issues, the goals, the principles? Section 216 and 239 of the Criminal Procedure Code requires this court to conduct a trial and is in form of receiving evidence at this stage. It says as follows, that is section 216 and 329. The court, before passing a sentence or making an order against an accused person under section 215, receives such evidence it thinks fit to inform itself as to the sentence or the order to be passed or made. In addressing section 216 and 326 that I've just spoken to, the Supreme Court in Murwatetu case had this to say at paragraph 43. So it said that therefore from the reading of these sections, it is without doubt that the court ought to take into account the evidence, the nature of the offense, and the circumstances in order to arrive at an appropriate sentence. And in compliance, therefore, this court directed the parties to file their submissions. And as I indicated last time, the court had the opportunity to receive, to read, and to consider the submissions by the prosecution, the victim's family, and finally, mitigation by the accused person. For the benefit of all of us, I will, in a nutshell, summarize what the prosecution have invited this court to take into account before meting out the sentence. Again, very briefly. The prosecution submissions are dated 6th of March 2024. Before those submissions, the court had sought for the records of the accused person. The court received the records, and the accused person is indeed a first offender. That fact has been considered in this decision. My understanding of the submissions by the prosecution that they have invited this court to look at the aggravating factors in this matter. And they have outlined them as follows, and I'll read them out. The prosecution invites this court to note that on 20th day of September 2018, the deceased Monica Kimani lifeless body was found inside a bathtub with her throat brutally slit and hands tied. The court is invited to note that the post-mortem report produced by Dr. Peter Ndegwa confirmed that the deceased Monica Kimani died due to severe neck injuries due to a sharp force. The court is being invited to consider that there was serious and grievous harm occasioned to the deceased. The court has been invited to consider that the weapon used was a dangerous weapon and that the offense was an intricate planning. There was intricate planning of the offense. And in capital letters, the court has been invited to note that there was no degree of provocation from the deceased person towards the offender. And finally, the court has been invited to note that after commission of the offense, there was an attempt to conceal the evidence. Not finally, there's one more. The court has been invited to consider that the crime had serious physiological and physical harm to the victim and the family. Based on these factors, the prosecution argues that this court should mete out the sentence as provided for under the law. They have invited this court to note that despite the decision in the case of Muratetu, the only thing that that case did was to declare, and I will put it clearly, that the mandatory, I will repeat, the mandatory nature of the death sentence is unconstitutional, and that it did not declare the death sentence unconstitutional. And so, without going into other areas of submissions which are reflected in my judgment hearing, the prosecution invited this court to pronounce a death sentence. The victim's family, in their submissions dated 7th of March, drew the court's attention to the sentence provided for the offense of murder, which sentence is stipulated under section 204, which says that a person convicted of the offense of murder shall suffer death. They led the court through the objectives of sentence, which I've spoken to and therefore I'll not repeat. And they invited the court to take cognizance of the fact that the accused person before the court did not play a peripheral role in the commission of the offense, but he was the main perpetrator of the offense. In that, they are saying that he did not only steal an ID card of a third party, but he used it to disguise his identity, changed his clothes and went to the deceased's house and brutally murdered her. They described the murder as being cold-blooded, ghastly, and barbaric. They have invited this court to consider that no amount of monetary compensation can ever bring the deceased back. And they have invited this court to note that the death of the deceased occasioned the family a lot of economic loss as the business of the family that she was manning in South Sudan collapsed, and that it was the only means of income for the family. Finally, the accused person filed their submissions in form of mitigation dated 10th of March. And I think it's important I take a bit of time in our understanding of what the accused person said, because he is the one on trial. So I will not summarize too much his mitigation, and also for the parties to appreciate that I've taken it into consideration in totality. The accused says that he's aware that nothing he says at this stage will relieve the pain of the deceased family. And he says the lesser he says, the better. He says that he expresses his sadness that such a tragic loss of life on extreme circumstances bordering, and this caught my attention, okay? He says that he expresses his sadness that such a tragic and callous loss of life on extremely circumstances bordering on an act of absolute madness that is beyond understanding, even to him, as he stands there convicted. He says that it is his prayer that the deceased family will find peace and that her soul will rest in eternal peace. He says that he understands the terrible fear and pain that the deceased must have underwent in the hands of the perpetrator, and he cannot even perceive the same. He joins the victim's family by saying that he does appreciate that monetary compensation cannot relieve the pain of the loss of a loved one. The court has been invited by the accused person to note that by the Supreme Court declaring the mandatory nature of death sentence to be unconstitutional, then it opened room and gave this court the discretion to mete out a sentence that is not necessarily death. And the accused then says that in that case, and again, this was very important to the court and for reading, because I come back to it. He says that in that case, it is his prayer that the court can mete out a custodial sentence. He says that although the victim's family in their submissions are calling for a death sentence, but the father of the victim, Bishop Paul Garama, was publicly heard saying that he will not take vengeance. And so, the court should consider his views. Finally, the accused person invited the court to consider that he is a first offender, that he was convicted purely on circumstantial evidence, and the period he has spent in custody. That, in my considered opinion, was the additional evidence given to this court in form of submissions by the parties at the close of the formal trial. In looking at the goals of punishment and in considering the objectives, I made reference to inclusivity And I said that before a sentence is meted out, the views of the victim and the community are extremely important. And so at this stage, I want to speak to the pre-sentence report that this court was given. Now, I must thank the probation department because they gave me an extremely detailed pre-sentence report. What comes out of that report is this: that the accused person before this court is 33 years old. His parents are alive. He has 3 siblings who, from the report, are also alive. It speaks to their permanent place of abode at Guta Estate, which is just adjacent to Lanet military barracks within Nakuru County. It indicates that this accused person completed his secondary school education in the year 2010. He then joined the Kenya Polytechnic and completed his training in the year 2011, where he qualified by being conferred with a diploma in food production. The report says that thereafter, and again this was critical for this court, he moved to Dubai, where he received training in tactical military at Dubai Police Academy and by a group known as Ogara Group, which he says that Ogara Group is a security firm with presence in Dubai, United Kingdom, and several European countries. And eventually, after that training, he was licensed to offer private security. The report indicates that at the time he was arrested, he was providing security in Kenya mostly to persons in political sector, and he was at an advanced stage of registering his own security firm. Outside his training and daily work, the report indicates that he's a staunch Christian. He has sung, produced several music videos, and he was actively involved in church activities. It is further indicated that when this offense was committed, he was in a relationship with one Jacqueline Maribe, who was his co-accused, and they were planning to formalize their relationship. At the time of the offense, they were both residing at Royal Park Estate in Langata, and they had resided together for over 1 year. Medical condition, the report indicates that he suffers from asthma since childhood, and that is usually triggered by colds and dust, but is on medication. It is indicated that he has developed now problems, and that arose out of a gun incident, which we spoke to in the judgment and in this matter. But it's said that the same is treated by painkillers, which gives him relief. On the offense, the report says that the accused person maintains his innocence and that he was shocked and depressed to be linked with the murder of the deceased. That he denies knowing the deceased, but acknowledges that he knows his brother. And it says that he grieves for the family of the deceased for losing her in a gruesome manner. The report indicates that he has good relationship with his family. The sister stood by him throughout the trial. They describe him, that is his family, and again this is important, as a social, overly generous, respectful to authority, committed Christian, and he believes in innocence, although he believes in his innocence, although he has painfully accepted the conviction. The family of the accused says that they have been stigmatized, faced a lot of stigmatization and financial drain in form of legal costs. That they are expressing empathy for the family of the deceased and pray that the perpetrators will be found. And finally, they pray for leniency in sentence. From the community point of view, the probation officer interviewed a senior chief of free area location, Dr. Samuel Macharia, who described the accused person as being well-mannered, respectful, and was not a threat to the community. That the community is shocked by the charge that was preferred against him and subsequent conviction. That they vouch for his good character, social standing, as they have known him to be a respectable youth committed to church activities. Bishop Shadrach Olo of Agape Sanctuary Church says that the accused person is a member of his church. He is steadfast in faith, relates well with fellow Christians, and at the time of his arrest, he was a choir master in the church. He pleaded for leniency. The investigating officer, Mr. Maxwell Otieno, is indicated in the report as having described the accused person as an extremely dangerous person, violent in nature, as demonstrated by the fact that he was involved in an assault case with one Rogers at Club 1824 when he was out on bond in this matter. And that the reason why the case did not go forward is because the complainant withdrew the complaint. And the investigating officer called for the maximum sentence provided for under the law. The community from where the victim hails from in Thika described the victim as a person who had a promising future. They were shocked at her death, and they called for a stringent sentence. The family of the victim. The family of the victim are reported in the pre-sentence report to have stated that following the demise of the victim, the death occasioned them monumental psychological impact, and they are still to cope with the said offense and death. And other than the father of the deceased, who has received psychological counseling, none of the other family members have had the benefit of the same. It is indicated that at the time the probation officer was interviewing the mother of the victim, she broke down severally and wailed, forcing him to stop the interview to allow her to calm down. She is said to have indicated that she does not understand what would cause anyone to brutally murder her only daughter, who was her confidant and a very close friend. It is reported that following the death of the victim and the deceased, she suffered prolonged depression and consequently suffered stroke. According to her, the only appropriate sentence is death. The father of the deceased is reported to have indicated that the extensive media coverage impeded their emotional healing. The younger brother of the victim is reported to have ceased watching news, stopped trusting people, limits his movement, avoids going to public places, and only does online jobs. It is reported following the death of the deceased, as already indicated in the submissions of the victim, having been the managing director of the family business in South Sudan, the business collapsed. The family became drained financially, and they were not able to meet their day-to-day needs, as that was the main source of their income. In a nutshell, the family of the deceased hold the view that the maximum sentence provided for under the law should be pronounced, and they acknowledge that whatever the case is, even that particular sentence will not console them or erase their pain. Finally, the probation officer, and again this is very important, and the court took note of the same. The probation officer, Mr. Andrew Kanyotu, in conclusion and his own observation, states as follows: he describes the accused criminogenic risk factors as follows: that he lacks stable partner relationships. He has antisocial personality patterns manifested by living on the edge. He is impulsive and a thrill seeker. He uses anger or aggression to control others. And finally, he says that the accused has a double personality trait. What is the recommendation in the pre-sentence report? He recommends that the court uses its own discretion in meting out the sentence, taking into account what is in the report and the sentiments of both the accused and the offender. So that's a summary of the submissions by the prosecution, the victim's family, and the accused. So what sentence then would this court be looking at? First and foremost, let's acknowledge where our sentences are provided for. Section 24 of the Penal Code recognizes the following forms of sentences. 1, a death sentence. 2, life imprisonment. 3, or an imprisonment for a term of years. Detention under the Detention Camp Act, if that were the offense committed under that act. And it's important to interrogate these types of punishments, because then one needs to do an exercise of elimination inclusive and justify why this would not be applicable. And so I speak to them for our understanding. Fine, forfeiture, payment of compensation, finding security to keep peace and be of good behavior, and any other punishment this court will find and deem appropriate. So this court cannot give a sentence outside those various recognized forms of punishment. When I consider these categories and types of punishments, I classify them into two: custodial and non-custodial. So again, the question is, having taken into account the evidence as was adduced in this court, taking into account the submissions at this stage of trial, is this an appropriate case for a non-custodial sentence? I'll deal with that. We have already spoken to the fact that a sentence must serve a purpose. And so what purpose would a non-custodial sentence serve? One of the goals that a non-custodial sentence would serve is to give an accused person an opportunity for rehabilitation. And so, is this accused person eligible for rehabilitation? My answer was in the negative. For simple reason that a person who is given an opportunity for rehabilitation must first and foremost himself acknowledge commission of the offense and the need to reform. Without that attitude, there will be no need to consider rehabilitation. It will not work. He will not appreciate, and of course then it will be an order in vain. Alongside rehabilitation, we have the goal of reintegration. And when one is considering reintegration, then several questions must be answered. We are releasing this person to the society. Is that safe? Is the society safe? We'll answer that question. What about restitution, restoration? I've already spoken to this and said this is a situation where you are telling the accused person, make good the harm. Is this a case where an accused person can make good the harm in form of monetary compensation? As I was dealing with this particular goal, my mind took me to a case I deal with on a day-to-day basis when I'm dealing with appeals and more so in civil cases, and someone has come before the court because they were involved in an accident and they suffered bodily injuries. And in the case of Coastal Kenya Enterprise Limited versus Mushiri, is a civil appeal number 84 of 2016. This is what the court said, and which I fully associate with. Money cannot renew a physical frame that has been battered and shattered. And so in my considered opinion, this is not an appropriate case where the sentence that is being meted out is aimed at restitution, restoration, and or compensation in monetary terms. What about reconciliation? Should this court give a sentence that would aim at reconciling the two families? Having listened to me read out the pre-sentence report, it is very clear that these two families are incapable of sitting to negotiate, to reconcile. Where does that leave the court? The court was left with only two objectives to look at: retribution and deterrence. And I've already spoken to them at the beginning of this judgment. That is where the court punishes the offender, at the same time deters the offender from repeating the offense if given an opportunity, and the general public from committing a similar offense. The purpose of law and the aim of law, in my understanding, is to maintain law and order and protect the citizens of a particular state. That is why one of the objectives of sentencing is community protection. And therefore, the sentence any court pronounces must speak clearly to the community condemnation of criminal conduct. At this point, I was drawn, and I'm entitled as a court, to take judicial notice as I talk about and discuss general deterrence, to take judicial notice of the social justice concept. And that concept, in my understanding, speaks to the court being live to the happenings in the society at a given time. And my mind as a court, my understanding, my reading, is that in recent past, there have been numerous reports of senseless murders targeting persons of female gender. Let this not just be my words from where I sit. In an article dated the 26th January 2024, Amnesty International Kenya noted that a woman is killed in this country in every 2 days. And I will quote from the article so that I attribute it to where it belongs. Let me read the caption from that article. Amnesty International Kenya strongly condemns the profiling, torture, and killing of women and any other individual based on their identity. Over 10 cases of femicide have been reported across the country since 1st of January 2024. That is, every second day, a woman has been brutalized and killed because of her identity. According to statistics from Africa Data Hub, between 2016 and 2023, over 500 women have been killed. The majority of those murdered were below the age of 35 years and were killed by intimate partners or people known to them. According to the Africa Data Hub, a regional network of data organization that traces such killing based on newspaper reports, it states that about 500 women have been killed in Kenya from January 2016 to 2023. Now let me draw ourselves back home. In an article published by the Daily Nation on 27th of January 2024, it indicates that 16 women have been killed since January 2024. The most disturbing was a case of Rita Mweni, a 20-year-old student at Jomo Kenyatta University of Agriculture and Technology, who was lured to a short accommodation apartment at Roysambu, commonly known as Airbnb. She was murdered, her body was dismembered, her head was dumped at a different location, and one can only but consider the words said by Dr. Jansen Odwal, the pathologist. And these were his words. He said, "This is the first time I've come across such an incident in my forensic life. I have never come across such an incident." And so when we are considering the public's denunciation of a crime, one cannot live outside the prevailing circumstance in the society. It is the understanding of this court that these reports speak to a situation whereby the social fabric of the society has been torn into two, right at the middle. And the court must then live to its role to protect the society. And so, having ruled out a non-custodial sentence, and may I just say this, the accused person is also not even asking for a non-custodial sentence. I read the submissions on mitigation, and in their own writing, they tell this court, Muratetu did not declare a death sentence to be mandatory, but then the court can give a custodial sentence. They say a custodial. There is nowhere in that report where this court is being invited to consider a non-custodial sentence. So we are at a stage of a custodial sentence. And I've already made reference to the sentences that this court can pronounce under Section 24. Fast track the judgment. The following factors have been considered by this court as I come to the tail end of the judgment. And there are only 3 sentences that are open to the court. A sentence for a term of years, life imprisonment, or death. The question that we all must ask is this: how many years, and what would be the basis for those years? Secondly, and for the lawyers before me, and today I am well populated, thank you for coming. We are all aware of the jurisprudence on life imprisonment, where one of the courts has said it is unconstitutional. The latest decision which I've quoted in this matter says that life imprisonment is 30 years. So the question that one would then ask is, if life imprisonment, and of course is acceptable, it doesn't mean the life which that person will physically live or be alive. So if it's 30 years and with remission, then we'll be looking at where this court is sentencing the accused person to 30 years. With remission, he serves 20 years and his life moves on. These are issues the court had to think over. I have, of course, taken into account issues of human rights. I've taken into account Article 26, that says a person's life should not just be deprived without good reason. I have made reference, and maybe I should then let you know, to the international instruments that speak, and I need to do this because it's important, to the preservation and the right to enhance an individual's human rights. The International Convention on Civil and Political Rights, which has been ratified and which then of course becomes part of our law under Article 2, Sub-Article 5 and 6, says this, and it's important that I read it out because you need to know that. It starts by saying every human being has the right to life. And I stop there and I tell myself as a court, every human being has a right to life. That every human being includes the victim and the offender. It then says this: This right shall be protected by law. No one shall be arbitrarily deprived of his life. Most of the time when we read these provisions, we speak to them as they relate to the offender. My understanding is they relate to both the offender and the victim. That convention states as follows: that in countries that have not abolished the death penalty, a sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crime. So these international instruments that speak to human rights do recognize that there are exceptional circumstances when the death sentence may be inevitable. Let's look at Article 4 of the Africa Charter on Human Rights, on Human and People's Rights, ratified on 23rd of January 1992. It provides that human beings are inviolable. Every human being shall be entitled to respect for his life. His, in my considered opinion, includes her life, and the integrity of his or her person. Again, it reiterates, no one may be arbitrarily deprived of this right. Muratetu reflected again. The Supreme Court says that you can indeed impose a death sentence for most serious offenses, extremely grave. So the question is this a case of serious crime? In answering that question, I considered the following. What the evidence said. And the first thing that was revealed by the evidence is the manner in which the offense was committed. I want to remind ourselves of the judgment I delivered on 9th of February, where I indicated clearly that the evidence of the doctor who conducted the post-mortem report indicated that the person who perpetrated this offense cut the throat of the deceased through and through. In that judgment, I spoke to an understanding that the person was not an amateur. The person must have had some training. And remember, the evidence even revealed that after the offense was committed, the deceased was put in the bathtub and the shower tap was put over to run the blood off. When I read the report presented by the probation department, where the accused person himself says, I have been trained by the Dubai Police Academy and an Ogara group, I thought that corroborates the finding of this court that there was full scale for commission of the offense. I do recall saying in that judgment that the manner in which the offense was committed did not at any time intend to give the deceased one more minute to live. I do recall throughout the trial, no any other than the counsel representing the accused person in this trial throughout kept on referring to the incident and the scene of crime as a slaughterhouse. Secondly, We have had the benefit of looking at the photographs showing the body of the deceased and the injuries. I would certainly not display them there. Certainly not. At least for the benefit of the family. And I did indicate in my judgment, no one would like to look at them again. Not once, not twice. Now let's look at, and this is very critical, because it is not the court just making an observation, it was a brutal murder. Let's look at how the defense, that is the submissions in mitigation by the accused person himself, describes the offense. I will now read to you how they describe the offense verbatimly. They say that it is a tragic, cardiac loss of life on extreme circumstances bordering on an act of absolute madness that is beyond understanding. So even the defense joins the victim's family and the prosecution and the court in arriving at the conclusion it was a gruesome murder. Horrific, frightening. Let's now look at another important aspect that the court has considered. The consequences of the offense. From where I sit as a court, each one of us is responsible for the natural and the probable consequences of our actions and or omission. So it's not just an issue of committed an offense, but the far-reaching consequences of that offense cannot be ignored. And so in this case, it is undisputed that the deceased was the managing director of the family's business in South Sudan. It is undisputed that the business collapsed after her demise. It is undisputed that that was the source of income for the family, and we can all appreciate the natural and probable consequences of that. I have already made reference to the fact that the other consequence of this offense is what has been described, and unless there is evidence to the contrary, I believed it because it's in the probation officer's report, that the mother of the deceased suffered depression and stroke, and she has hardly healed. I've spoken to what the brother is said to be undergoing. This court, and I never lose out on anything, I try to get as much of in-depth of the material before me as I can, has been invited to take cognizance of the fact that the father of the deceased at one time said, I will let go. That did not form part of my record, because what formed part of the court's record is his sentiments as expressed in the Brevet report, and that is what I would safely go by. But I'll be concluding with one or two other findings that could probably remove us from that mind thought that the father said, do not, vengeance is not mine. I also want us to just, in concluding, other than looking at the manner in which the offense was committed and the consequence of the impact of the offense, I took a bit of time to look at the character of the accused person. I have already spoken to how the probation officer describes him: aggressive and social personality, and concludes he has double personality trained. But let's look at what else this court was able to gather while hearing this matter on the character of the accused person. It was the evidence of the guards at Royal Park Estate where he was staying that he would not allow himself to be searched. He would brandish a gun and say, "I work at State House," and just drive off. It is the evidence of the brother of the deceased that even during the hearing of this case, at one time, he blocked his car when the case was going on. And of course, you have heard from the IO, even when he was out on board, he was still involved. I'm not condemning him because there's no charge before me. But the court cannot avoid looking at this. Because at the end of the day, the question is this: is this a person you want to release back to the society? And these issues become extremely critical for consideration. Finally, this matter and the evidence adduced does not lead to a conclusion that this murder was accidental. That the perpetrator did not have an opportunity to think about the consequences of his action. It was intentional. It was not a defensive act. It was not out of provocation. It was planned. It was intended, and it was executed. And those who do not subscribe to Christian faith, bear with me. I do, and that's the only place I could make reference to. In the book of Job, chapter 1, verse 12 to 13, this is what is written. I think I looked at was it NIV? You can find out. It speaks to the same thing. This is what the Lord said to Satan. Behold, all that he has is yours. Only do not lay a hand on his person. I will repeat. Behold, all that he has is yours and is in your power. Only do not lay your hand on his person. The provision of life is the preserve of God. And I find no room anywhere for a person to take another person's life unlawfully. In my very final conclusion, join me in listening to these wise sayings on murder. 1. In the act of murder, one person's lips and broken hearts that can never be healed. I have said the accused person before me is 33 years. The deceased was 28 years. Thirdly, the act of murder is a heinous crime that challenges the moral fabric of society and demands justice. And so it is not just a loss to the immediate family. Of course it is in the highest degree, but it's a loss to the society. when one is killed unlawfully. And so, based on everything I have said, I have ordered that the first accused person before this court being Joseph Kuria Irungu alias Jowie, shall suffer death as provided for the offense of murder under section 204 of the Penal Code of Kenya. Unless that sentence is lawfully set aside by a court of competent jurisdiction. That is the order of the court. Thank you. Yes, Counsel.
Yes, my lady. For purposes of appeal, the praise we provided copies of the judgments and sentencing decision and judge proceedings.
Any other counsel wish to address the court?
My lady, patient for the state, apologies I was late. We just want to thank the courts for bringing this matter to our close. We're in alignment with your sentence, and we still would like a copy of the sentence once it's available. But we are grateful for the court's indulgence and the way it has handled this matter.
Any other?
Yes, my lady, on behalf of the victim's family, we also wish to thank the court for sincerely the manner in which the court has handled the proceedings. The family feel that justice was being done. We also wish that the court supplies us with the sentence and judgment to find itself. Thank
you. Okay. A right of appeal is a constitutional right which the accused person should feel free to exercise. Is important. You are entitled to the proceedings, the judgment that the court will delivered on today's judgment. And when the file was brought to me, and I'm sure by now my judgment, it was actually available the same day I delivered before 7. So just ask the Honorable DR to give you the proceedings and the judgment. I've always said that my judgment is never accessible until I've delivered. My judgment on sentence is here. As I was delivering, I could see quite a bit of typo. So it's just an issue of polishing it. You should have a copy. I'll sign a copy before end of day, and you should have a copy. Okay? So unless there is any other person is addressing the court, may I have the last bite of the check? First and foremost, please allow me to sincerely thank all of you, and that means the parties in the matter, the members of the public, the press, for the support you have given this court. I took over this matter from my brother Justice Wakiaga, and as much as I know there has been a bit of complaint that he's taken long, we did the best we could. We lost a bit of time during COVID when activities of the court slowed down, but take it from me, when you look at the way this matter, and I'm not blowing my own trumpet, I have no reason to, but one thing we must appreciate, that this matter was being had alongside other matters. And let me say something that probably you wouldn't know. When I was presiding in the criminal division of the High Court here in Nairobi before I was transferred, I did a prison visit at the Nairobi remand, and those inmates took me on this matter. And their question was, kwa nini unakimbiza kesi ya Jowie na Maribe na walituacha hapa na uendeshi kesi yetu haraka? I didn't realize that we were moving fast with this matter. So for the members of the public who have felt that when we talk about only 6 years, it's also important to consider that there are other matters. And so please, we are not making an excuse for anything, but it's good to just make an understanding and, of course, apologize for any inconvenience that may have been caused by any delay in the hearing of this matter, but set the record clear, we did the best we could. And so I thank you for your support, because other than the time we had a bit of challenge when I think Professor Nandwa had a personal issue, all the time the lawyers were in court, and we were able to move on. I have not had a disruption in this matter. The press, I must really congratulate you. I have not had to someone here to say, what did you report? Except recently, which I will not talk to, but maybe I should. When I was reported to have on my way here, and I'm reported to have said that the accused person what other media house reported. Sikujua hiyo wametoa wapi. Also choose the battles to fight. But what I'm saying is that generally speaking, I really want to thank you. I know you are quite a number of you, and you are understanding, but I've not had any reason to complain that you have not reported these matters factually correct. So thank you very much. Please keep up the good job you're doing. For the rest of us, thank you for coming, supporting the judiciary as it were. Your patience with us is highly appreciated. And with that, I wish you a good day for the rest of the day. For our staff, the court assistant, and of course, my other good friends. I can even see one whom I've worked with for a long time, the gentleman there. Tumefanya kazi miaka ngapi? Over 10, eh? Please don't say anything more, they'll start guessing my age. So thank you very much, court assistant. Unless we have any other matters that are before the court, I would request then we officially adjourn the court.
Imagine waiting for either someone or just something like for around 6 years. And then after these 6 years, you actually, hata ujui like how the ending will be. What am I talking about? Hii kesi ya Jowie Irungu na Jackie Maribe, like hii kesi imeka like for a solid 6 years. What's the verdict? And what do you think? Justice imeserviwa? Has it been served cold or hot? Tuambie hapo kwa comment section. My name is Monica Kimani, and this is the Dorian 254, Home of Inspiration. And today, I'm joined by an amazing guest, Tuongema 1212, to do what you also think about. Hizi vitu zenye tunaongelelea. Niaje Jeff?
Fiti sana.
Mko aje?
Niko bie mbaya.
Niko bie. Siku zote wanasema niko best.
Niko bie fiti.
Niko best. Wewe kwani si Gen Z? Niko best in the whole world. So, kuna like already say kuna whatever, like the Jowie story is all over the place. Yeah. What do you think about the whole story?
Hii story ni noma because ni Kenya. Unajua tena history ya Jowie imetokea penye vitu, so many things in happened about murder. Ni mayouth, unapata mayouth wana murder mayouth wenzao. So hiyo story sasa imetokea at wrong place. Ilikuwa 2018 but right now venye January kulikuwa, February kulikuwa, and now March, na bado hiyo story venye inaendelea si fiti. Imetokea wrong place. So judgment yake unasikia ilikuwa inafaa kuwa jana. Ikakuwa postponed to 13. Hapo ndo penye Judge Grace Nzioka alisema this is the final verdict, haipeleki mbele. Kama mja submit hizo manini, maloya wake hawaja submit hizo mabarua. So hapo ni final wana finalize kila kitu.